All right, welcome to today's webinar. It's on corporate planning. As most of you know, the last webinar last month and the next webinar in October, all three have been sort of about personal life and business planning, very often called succession planning, planning for the future. I mean, that's really what this is all about. Is how to plan in advance for things that may occur in the future. And it's really important information. In fact, these are really probably the most important webinars that I really do. I mean, I know that when I do wholesaling or seller financing, a million people jump online because that's how real estate investors make their money. But this is really planning ahead, and it can really solve a lot of problems if you plan ahead. And so at the end of the year, we try to kind of go through this because the end of the year is always a great time to start thinking about the future and to plan ahead. It's a great time to review your corporate structures, your family trust structures, and how things are all working together. And if you need to make revisions, the end of the year is just a great time to kind of do that. So that's been August and September and October's webinars. The one in October is essentially year-end planning. And that is the end of the fourth Friday in October, as usual. And then November, December, and January, I usually leave blank as far as webinars. But I think we're going to open it up. I think we're going to send out an email blast, and we're going to ask for your input and get responses back from the attendees of the webinars on what topics you want to hear about. So be thinking about that. And if you already have some ideas for topics, let me know. Send me or Nicole an email, and we'll put it on the list of possible topics to do webinars on in November, December, and January. Particularly in November, December, because we do it on the fourth Friday. That always falls around Thanksgiving and Christmas, so we kind of do flexible timing those months. Okay, actually, I've had some recent conversations with some wholesalers who have been investigated by the Division of Real Estate here in Utah. And so there seems to be some confusion there, and I may do a webinar on licensing, real estate licensing. So that's an option. So anyways, be thinking about that. Let's get on with today's. How do I make this? There we go. Okay, remember that this webinar is copyrighted by my office, but it is, as always, it is available on my website. So after the fact, you can always go back to the website and see the video recording. We are recording right now. So no reason to steal it. You can have it for free. This is an educational webinar. It's not legal, tax, or accounting advice. Just remember that. If you have specific questions, then just feel free to call or email us at the office, and then we can talk to you specifically about your situation. Okay. This is just my background. You've all seen this repeatedly before, so I'm not really going to go over it. There's a little bit more about me. Boop, 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 boop. Things my office does: entity formation, asset protection, estate planning, title and escrow, transactional documents. In fact, we are moving to a situation, kind of changing my business model a little bit. And after 15 years in this business, I'm pretty confident that my forms are pretty solid. And we're going to start selling form packages that you can use over and over and over again. Rather than doing customized documents. It's a way to save you guys money. Always looking to save you money. So you'll start hearing information about that in the coming months. Okay, today's agenda. We're going to review asset protection and estate planning, and then transfers of these interests. And what the transfers of this interest really means is, last month we talked about family planning, which is basically your estate plan. And in your estate plan, there are certain documents that are included. One is the family living trust. I really recommend everybody have a family living trust. And if you own an entity or if you own real estate, you must have a family living trust, because those assets can't be transferred unless you have a family trust or you go through probate and the court appoints an administrator of your estate. So if you have a house and you die, your heirs can't sell it until they go to court and get a court order for that appointed administrator that then has the authority to sell that real estate. The same thing is true if you own an LLC or an S Corp. Same thing. You can't transfer that or do anything with it without court appointment. And so you might have this LLC that's got 10 rental properties in it. You die, and nobody can run that LLC. So you need to plan in advance of what's going to happen if you die or you become incompetent or if you're in an accident, et cetera. So that's kind of what we're talking about today. But it really does all start with that estate plan and getting up that family living trust set up. And then there's other documents in the estate planning package, usually a will, which kind of works in conjunction with the trust. Then there's powers of attorney, which are great ways of handling situations that might arise in the future. There are healthcare directives and HIPAA releases, and the quote-unquote living will. The living will is to pull or not pull the plug, which is an interesting thing. Previously, years ago, most clients were like, extend my life support. That seemed to be kind of a common choice. Most people wanted to extend things as long as kind of rationally possible. I would say in the last couple of years, all my clients are like, nope, pull the plug. We're done. So interesting change in sort of family's perspective on things. But just kind of as a side note, that's where this kind of your future. I see now the meds are kicking in. Your future planning really starts with that family trust. So if you missed last month's webinar, go back to the website. It's available there. You can watch the webinar on estate planning. And today we're talking about corporate planning. So today we're talking about how to transfer your interests in your businesses and deal with those in the same way your estate plan deals with assets upon your death. And so transferring those interests is, what do you do with your membership in an LLC or your stock option, your stock in an Inc. Or something like that. And there are voluntary transfers. That is when you actually make a decision. I want to transfer my interest in this LLC to blank. Then there are involuntary transfers. These, we'll talk about, specifically what they are in a minute. But these are when you are sort of forced. For some reason that happens, you're forced to transfer your membership somewhere else. Okay. Asset protection. Again, the reason we set up entities is really protection. That's the whole point. And in asset protection circles, most of my clients, especially in real estate, will have two basic entities. One is their S-elected LLC or their S Corp, and this is the entity that they will run their real estate commissions through, their flipping, their wholesaling. It's really a tax savings entity. But as an S Corp, only a human being can own that. And so if you have a family trust set up, your family trust cannot own that S Corp because by tax law, it's impossible. Your S Corp, your family trust cannot own an S Corp. Only a human being can. And so that's one kind of entity, that's this tax savings one. And then most clients have an LLC for their rental properties. This is holding assets or an asset holding entity, and it's usually a series LLC these days. On the series LLC or the asset holding LLCs, we generally recommend more than one member of that company because there are additional asset protection benefits when you have multiple members as owners of the entity that owns properties. If you're a single person and you don't want to share ownership with a family member or a partner, which is fine, we get that. There are other ways to make another member of that LLC. For example, you can set up a corporation. And a corporation is a separate identifiable entity under the law. And then what you do on your LLC that holds your rentals, you just partner with your entity. So you make your corporation a 5% owner of the LLC, and then technically you do have more than one member. So there is a way to bring other people involved for that. But again, asset protection, you want a solid entity, you want all the correct documents. Over the summer, in June and July, I talked about corporate governance issues, and those webinars are also available on the website. So we talked about the kinds of documents you need, how to run it, how to hold meetings, and all the kind of things of making sure that entity that was initially set up is run correctly. So that's step number one. Make sure you've got a solid entity, you're running it correctly, and if it's holding assets like rental properties, have more than one member or partner involved. Okay, estate planning. Again, the key in estate planning, and if you go to an estate planning attorney, you'll get a different recommendation than I give you. In estate planning, the estate planning attorney is thinking about how to allocate your assets upon your death. So what they're going to do is they're going to recommend that all your assets go into that family trust, including your LLCs that own rental properties. I disagree. Okay, I do not put all of your assets into the family trust, and that's what I'm going to talk about. This whole webinar is about what I do instead of that. And the reason the estate planning attorney says that you should put everything into your trust, that's an estate planning objective. And when you die, whatever that trust owns, that trustee, or essentially the successor trustee of that trust, probably your heirs, your children, or someone, whoever you've named as the successor trustee, they have immediate access and control over those assets. So they have immediate access to sell a house, they have immediate access to run an LLC, etc. And so for estate planning purposes, that makes sense. I mean, the estate planning attorneys aren't saying anything wrong. They're accomplishing a very valid estate planning objective. And for most families with, where they have day jobs and just their personal residence and maybe a vacation property, that makes a whole lot of sense. But my clients are all real estate investors that have large portfolios of rental properties and multiple independent businesses. Okay. And my clients have a different objective, and their objective really is more asset protection than estate planning. But the way we do things, we can actually accomplish both. But we just accomplish it differently than an estate planning attorney would do it. So again, asset protection, you want more than one member. In estate planning, your family trust would be the only member of that LLC, right? That's the estate planning. When the estate planner says, yes, we need to transfer your LLC to the family trust becomes the 100% owner of that LLC. And as soon as it becomes a single member LLC, you've lost your asset protection benefits. And a family trust has no asset protection benefits during your lifetime. Now, once you die, that family trust becomes irrevocable. And at that point, yes, it's a great asset protection tool. But while you're alive, there's no asset protection in a family trust. Okay, so how do I accomplish these two objectives, asset protection and estate planning? Well, it's through transfer documents, corporate transfer documents, and that's really the topic of today's webinar, is these corporate documents that allow us to accomplish both, get asset protection while we're alive, but when we die, then it all goes into the family trust for control and what we call succession, corporate succession. Okay. Voluntary transfers. This is transferring of ownership among different people. Okay, so among married partners, if you're married and you own an LLC and you want to put things into an LLC, etc., these are some of the things that we consult with on our clients. And so let's say, you have an LLC and you own it 100%, but now you're like, after you've heard this, you're like, oh, I need to add my wife to the LLC for asset protection purposes. Can I do that? First thing you need to do is check the documents that you have. Many asset protection LLCs actually prohibit or prevent transfer of ownership, and that's because it makes it a stronger asset protection tool. So usually you have to do an amendment to transfer to a spouse or to another person. So you got to confirm your own documents as to what the process is to transfer ownership. Mortgage counting rules, and this is kind of why I bring this up with married partners. And I could teach a whole nother webinar on how we count mortgages and qualifying for mortgages. As you know, that you can get about 10 mortgages in your name, to buy rental properties. But when you count how many mortgages you actually have, you have to count mortgages not only that are in your personal name, but any mortgage on a property that's owned by an LLC that you have ownership in. So if you and your spouse own an LLC with 5 rentals in it, and all 5 rentals have mortgages on it in your wife's name. So she went out and she got all the mortgages, and there's 5 rentals, and the two of you own this LLC together. Well, she obviously has 5 mortgages under her name because those are the mortgages are actually in her name. But guess what? You as the husband also now have 5 mortgages. not because the mortgage is in your name, but because you own an entity that owns mortgaged properties. And so you have ownership in these properties that have debt on them, and you're also responsible for that debt. So very often with married partners, if their goal is mortgage counting to maximize the number of mortgages that they can get, very often we set up two LLCs, one for husband, one for wife. They each go out and they get their 10 properties with their 10 mortgages in their individual names. Then after they've maxed out and they can't get any mortgages, then mortgage counting is not the objective. Then we combine it and we put husband on wife's LLC and we put wife on husband's LLC and make those multi-member LLCs for better asset protection. Okay, so there are times when we don't make asset protection our number one goal because we're making mortgage counting our number one goal. And we just understand that in the meantime, while we're going around and getting these 10 mortgages, that yes, we don't have all the solid charging order protections and stuff that a multi-member LLC has. Okay, so transfers back and forth, we very often do that. Management percentage interests. This is if you're partnering, and generally when we set up our LLCs, we always make them manager managed, and we make one person the manager, even when there's multiple members. That way, that manager, it makes it much more efficient and economical for that manager to kind of go do things. And you have to worry about percentage interests. The dual managers, good and bad. That is that if you have dual managers, generally if we do have two managers on our LLCs that we set up, no single manager can do anything alone. Because if you really want a mutual decision making and management, you don't want one of those managers going out and buying a rental property that the other manager doesn't want. So generally when there are two managers, there's more control. But it does make it harder to do transactions because you both need to sign. What we can do if you do have two managers on your LLC is called a corporate resolution authorizing any single manager to act on behalf of both managers. And if we've set up your LLC, then that document is actually already in your packet of documents. So you already have that in the event that you happen to have two managers and only one of those managers can go to a closing. You can fill that out and authorize that one manager to show up and sign a loan. Transferring back and forth with husband and wives, generally there's no issue because husband and wives generally will file jointly. And so because remember, if you become a member of an LLC that owns an asset, suddenly you just received value, and that could be a taxable event. And if you give ownership away to somebody, you've lost value, and that could be a taxable event as well. So anytime you transfer, voluntarily your membership interest in an LLC, you should run it by your accountant just to confirm, will this or will this not be a taxable event if I give 50% of my LLC to somebody else? Again, with husband and wives, it's usually not an issue. But if you have other people, non-married people in your LLC or want to bring them into your LLC, check with an accountant and ask them about whether or not that'll be a taxable event. Okay, which is what I just said. Non-married or family partners, confirm with accountants. Okay. Now, many people will want to add children to their LLCs for asset protection, just because it makes it more multi-member, which is again stronger. And they also want to start transferring assets and money to their kids while they're growing up. And that's actually a great thing to do with kids, and you can build up their retirement. Now, if you were just to give an LLC that had a rental property in it to your child, that really would be a taxable event because they're receiving whatever that equity or value of that property is as a gift, and gifts are taxed even to children. Now, currently, you can gift to anybody, children or anybody else for that matter, up to, I think it's $17,000 or $18,000 a year, tax-free, and it doesn't calculate into their overall inheritance and the tax deductions. When you die, you can leave your estate, up to about $5.5 million or $11 million to your children tax-free, but you can actually do it while they're alive. And if you keep it under that number, that $17,000, $18,000, you can actually start giving away ownership and value to your kids completely tax-free. So if, I actually had clients whose parents had two rental properties in an LLC and they wanted to give them to kids. But of course, if you just give them to kids, it's a gift and it's taxable. And they didn't want to wait until they were dead, the parents. The parents didn't want to wait until they died for their children to get access to these rental properties. And there's about $100,000 of equity in these two rental properties as far as basis, because you got to check what the basis is and what the net equity is and the value and the gift, all that. And that's what your accountant is for. So they had about $100,000 they wanted to give to their children. And they had 5 children. Now remember, you can give up to about $17,000 per child. So they were able to give almost the entire LLC in 1 year. They just gave 17% of value, and we kind of did the math and the calculations, to the 5 kids. And the parents kept the remaining, I don't know, it's probably like 15 or 20% of the LLC themselves. So the kids essentially got a gift of less than $17,000 in December of, let's say, 2012. And then in January of 2013, the parents gave the rest of that LLC to the children. Then, of course, the values were far less than $17,000 at that point. And so now, boom, the 5 kids are the 5 owners of this LLC completely. They each have their 20% share each for the 5 kids. The parents gave away $100,000 completely tax-free. So that's one way of, I kind of bring that because that's one way of transferring these assets pre-death and tax-free. Okay? With unrelated partners in an LLC, anytime we have unrelated partners in an LLC, I always recommend a buy-sell agreement. We're going to talk about that in detail in just a sec. If you're a single person on an LLC, you don't need this. If you're married, you don't really need this. If you're partnering with a brother or sister or parent, I still usually recommend it because it does solve problems that might arise with family. But I have many clients that partner with siblings or something and they don't do this. But if you unrelated partners, you definitely want it. The buy-sell agreement is an additional document to the LLC. And it's an agreement among the members of what is going to happen in certain events. And because what happens is if you partner with somebody and you've got a couple of rentals in this partnership, that's great. And then your partner dies. What happens? Well, I don't know. Depends on how your documents are set up. If you don't have a buy-sell agreement, you don't have the transfer on death agreement, which we're going to talk about in a second, and it was in your partner's personal name, then his estate is going to have to go through probate. They're going to have to appoint an administrator. That administrator would then step into your partner's shoes, and then suddenly that's your new partner. So it's, if your partner's married, it's probably going to be your partner's spouse. And suddenly you're going to have the spouse of your partner that maybe you don't like. And now you're in a partnership with somebody you don't like. And what do you do about it? Well, the buy-sell agreement really covers those situations of what happens when somebody wants to sell their membership, because do you really want your partner selling their membership to somebody that you don't like or want to work with? Okay, so you want to control that situation, which is why when we set up our LLCs, the base document for our LLCs and asset, that we do for our real estate investors prohibits transfers without amendment to the agreement, which means you as the other member have to agree to that transfer. And the buy-sell agreement, what it does is if your partner wants out and wants to sell to somebody else, you get a right of first refusal, which means your partner has to offer his membership to you to buy before he or she can sell it to somebody else. That's what a right of first refusal is. So that way you can decide, okay, great. That partner wants out, it's like $50,000 that his value in this LLC. He wants to sell it to somebody else because he's done with real estate. But I can let him sell it and just have a new partner, or I can buy it myself and take the ownership completely and not have a new partner. So again, that's a right in the buy-sell agreement that is really critical in that event of your partner wanting out. Valuation obviously becomes an issue, but there are great accountants out there who are business accountants and know how to value businesses, and they do it as a full-time living. So you just got to find an accountant that knows how to value an LLC. With real estate, it's actually pretty easy. All I got to do is just look at the net equity in that property, and that's the net equity of the LLC. Okay, so with unrelated partners, we always, recommend a buy-sell agreement. We'll talk a little bit more about that in a second, I think. Yep, we do. Okay. Involuntary transfers. This is a transfer that might happen involuntarily. For example, divorce. You're a husband and wife, you're married, you got this LLC, you own jointly, okay? If you get divorced, the court's going to make you divide that asset up. So you get in kind of, you each hire your divorce attorney and you go into negotiations, and you can certainly negotiate that one member will transfer it to the other member, and maybe one member will take the credit card debt, and you can work this all out. But it is something that will be forced upon you. And so in the event of divorce, the ownership can change, and it is court ordered through the divorce decree. I've had many clients ask about a postnuptial agreement. Now, you all know what a prenup is, a prenuptial agreement, which is before you get married, you decide how these assets are going to be allocated, right? And I know it may not be romantic, but it is necessary. In all seriousness, we all want every marriage to last forever, but 50% don't. So I really recommend prenups for anyone who gets married. And you know what that is, right? What about a postnup? Can you do a postnuptial agreement among the spouses? And the answer is yes, you can. After you're married, you can decide at a later date how you want your assets divided up in the event of a divorce. There are a few more hoops to jump through with this. Each party, so the husband and the wife must have their own counsel. So one lawyer, I could not write a postnup agreement for a husband and wife. So each party has to have their own attorney, their own representation, and it has to be negotiated, and then, of course, reduced to a writing agreement signed by everybody. And when I talk to divorce attorneys who do this kind of work, they're very blunt. They're like, yeah, we can do your postnuptial agreement, but 9 times out of 10, those negotiations result in a divorce. Because at that point, you're married, but now you're talking about how you want your assets set up. And it can get bitter. So it's not the easiest thing to do. It's probably uncomfortable, but the fact is, yes, it can be done. So just kind of be aware that in the event of divorce, if you don't have a prenup, the option to do a postnup is an available option for you. And FYI, I do not do those. I won't touch those. I don't touch divorces. I don't do any of that. That is not my job. So I've got some recommendations for good divorce attorneys, but not me. Okay, incompetence. So whether you're married or working with somebody else, what happens if they become incompetent? They go crazy, or we could even say they go into a coma, right? So they're not around to make decisions. They're not able to make decisions. The best method to take care of this is a power of attorney. If there's the two of you and you're both managers of an LLC, you should do a power of attorney one to the other, so that in the event of incompetence, they're called springing powers of attorney. So they're not valid unless you're judged incompetent or comatose, and unable to speak, or unable to make your own decisions. So they're kind of sleeper powers of attorney. They just kind of sit and wait. And then if you are ever incompetent, then they spring into action, and then they're valid. But that allows your partner, even if spouse, because even if you're married, that management job doesn't automatically transfer if you're incompetent. It's not like, oh, well, my spouse is incompetent, so then I can just make decisions for them. It does not work that way. You need written powers of attorney to act even on behalf of a spouse if you become incompetent. Okay, so powers of attorney are real great tools and documents to have to prepare for that eventuality of something happening mentally to your partner. Okay, court order. A court may come in and sell off your partner's membership interest in an LLC, usually resulting from a lawsuit against your partner for other matters. So maybe your partner was in a car accident and sued by the family that was killed, and they've got a $5 million judgment against them. And remember, one of the reasons we want multiple members is this charging order protection. because that's going to protect the asset inside the LLC. What happens is the court orders that the members, the debtor, your partner, we call him the tortfeasor, the person who blew it, got into an accident, screwed up. His membership goes to his creditors, the family that was killed, or the estate of the family that was killed. Or if it was a bank, maybe this guy had a loan and defaulted on a big loan and owes his bank lots of money, and the bank wants access to these properties that he owns with you. The bank gets a charging order. Now, the way my documents are written is we maximize the charging order benefit. So that bank or that plaintiff or whoever comes in and steps into your partner's shoes, they only have membership interest as far as distributions. So if the LLC distributes profits, then the profits that would have gone to your partner will go to the bank or the plaintiffs in that case. But it prevents them from any managerial control or vote. So all they are is a recipient of money. And they're also a recipient of the K-1 tax thing too. So they might end up paying taxes. But the asset itself can't be liquidated. The court can't come in and force you to sell off those properties. So your asset and your percentage ownership is all protected here. Okay, which is why, again, we want multiple member LLCs for asset protection. Okay, in bankruptcy, kind of the same thing. If your partner ends up filing for bankruptcy, it's the same thing. The bankruptcy court can come in and step into the shoes, but they come in as a recipient of financial benefit and tax allocations, not as a true member with any kind of voting or managerial rights. Okay, death. What happens if your spouse dies or your partner dies? Okay, we use transfer on death agreements. Remember I said that an estate planning attorney would probably put this LLC into the family trust for the husband and wife. That way, when they die, it's already in the trust, it's done, it's good. It's good to go. And that's great for an estate planning purpose. But you lost your asset protection while you were alive. So when we set up LLCs, we keep the members, multi-member LLCs during their lifetime. And then we use a transfer on death agreement, which is an agreement among the members that says, essentially, when I die, I want my membership to go to blank. It's that easy. Okay. Most clients will fill in that blank with the family trust, which is kind of the normal thing to do. It's like, when I die, I want the family, my trust, to take my ownership. Therefore, the trustee of that trust can access it and control it and use it and do whatever. Okay. But it doesn't have to be your family trust. You can automatically transfer it to your spouse. So let's say husband says, when I die, I want my membership interest to go to my wife. If my wife pre-dies me, then it can go to our trust. So you can do stuff like that. If you're non-married, you could say, in the event of my death, I want my membership interest to go to my partner. That's fine too. And remember, at your death, the taxes are different. Remember we talked about this, that possibly anytime you transfer membership interest in an LLC, it might be a taxable event. We talked about kids and getting around that and making those $17,000 gifts. When you die, right now under current estate tax law, you can give up to $5.5 million approximately as a single person, or $11 million as a married couple, to heirs or others, tax-free. So for most of my clients, saving on estate taxes is not an issue. Most clients, only the top 0.5%. Does this even matter? Very few Americans really have to worry about estate taxes. Now that can change at any time. Congress can vote and lower that amount. They haven't done it in the last 10 years, and it's pretty much only gone up in the last 25 years. But it's possible that in the future that tax-free transfer amount could go down. And just kind of be aware of it. Just call us up. Call up an attorney. Just kind of Google it. I mean, good grief, you can Google everything now to see how that changes and whether or not that's going to affect your estate or not. But for most clients, again, estate tax planning is not a consideration. Most clients, it is asset protection during their lives, and then ease of transition, ease of succession, and avoidance of probate when they die. Those are the major goals that we're trying to accomplish, not estate tax lowering. So these transfer and death agreements are great. And anytime our estate planning package includes the transfer and death agreement. So if we set up your family trust, whereas an estate planning attorney say, great, here's your family trust, and here's a transfer of membership agreement from your LLC into your family trust. That's what an estate planning would do. I won't do that. I'll leave your LLC in your name and then create this transfer on death agreement so that your membership in that LLC doesn't transfer to your estate until you die. Great tool. We use them all the time. Highly recommend having them. Next page, again, this is kind of already kind of talked about this, unmarried family partners, incompetence. The buy-sell agreement will cover incompetence and what happens. It can act like a power of attorney, or you can do a separate power of attorney. We kind of discussed that on the previous slide. Disability and death. In a buy-sell agreement, we talked about the right of first refusal if your partner wants to sell. If your partner becomes incompetent, then the buy-sell agreement will allow you to take over, or a power of attorney will do that. What if your partner becomes disabled and unable to work, or if they die? What the buy-sell agreement does is it provides for the option of buying life insurance or disability insurance on the members of the company. So here's how this works. When, let's say it's you and your partner, and you have a buy-sell agreement, and you've bought this life insurance for the members of the company. When your partner dies, normally his membership would go to his estate, his spouse, his kids, whoever, even if you had a transfer, and if you had a transfer on death agreement, okay, it would go to whoever the transfer on death agreement said. But if you have a life insurance on your partner, what happens is that life insurance kicks in and it buys out your partner's estate. So they get cash from the life insurance policy and you get their membership. So its membership automatically transfers to you. So now you have the whole company, and your partner's estate was essentially cashed out and gone. So that's why with unmarried family partners, in this buy-sell agreement, we really do recommend this buy-sell agreement and getting this death, life insurance, or disability insurance, because they're very cheap. It's a very cheap policy. Could be even less than $100 a year kind of thing. And it could literally give you full ownership when your partner dies. And then you don't even have to worry about their estate. Okay. Can you also do a transfer on death agreement? Absolutely. You can do a transfer on death that says, and you really should, if you have an unmarried partner, you should have at least either the buy-sell agreement with insurance or a transfer on death, so that his membership interest goes to his family trust and can avoid probate. Remember the probate thing, it's going to cost you more to go to probate than it will to set up a family trust. So kind of FYI, it is cheaper to set up and have a family estate plan package done through my office than it is for me to handle your probate case. So it is cheaper. And when something does happen, everything is automatic. It's great. I can't tell you how many real estate investor clients come and say, hey, I found this great deal and the dude's dead and I want to buy it this week. And I'm like, sorry, dude's dead. We got to go through probate and have the court appointed administrator. And it can take if there's no dispute among the heirs and everyone's playing nice, it can be done in Salt Lake County in 2 weeks and cost a little over $1,000. If the heirs dispute things and challenge things and they can't decide who the administrator is going to be and blah, 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 it can take months and months and months and be thousands and thousands of dollars. So again, that family trust eliminates all of that. It's fantastic. So court order and bankruptcy, again, it's the same charging order discussion that we did. We talked about with married partners. And so that's done. Okay, for unrelated partners, again, the big key is that buy-sell agreement, that additional document. It covers all the involuntary transfers. So it covers if somebody wants to sell their membership, if somebody becomes incompetent, if somebody becomes disabled, if somebody becomes divorced, if somebody dies. All of those are covered in that buy-sell agreement. If you want an alternative to a buy-sell agreement, you can use a transfer on death. Again, my preferred with unrelated partners is the buy-sell, but the transfer on death works too. Usually the transfer on death I do with married partners, and single people. And you definitely want that life insurance policy on your partner. And that's just a great way to take care of things in the eventuality that somebody dies or becomes incompetent. Okay, yeah, wow, that's it. We're done. I made it through. Great, almost 45 minutes, and I didn't pass out. So good thing. I'll leave things open for some questions. Remember that Friday, October 23rd at noon is our next webinar. It's year-end planning, things to do at the end of the year, from sort of corporate housekeeping. I know many people at the end of the year, they'll go through all their old clothes and throw away the clothes they haven't worn in a year kind of thing. Yeah, that's what we're going to be talking about, that kind of stuff. Year-end kind of housekeeping and how to plan for the coming year. And I might bring in a guest on that one. So that's October 23rd. Remember that we can do your transfer on death agreement. We can do your buy-sell agreement. And we can do your family estate package. This month, it's normally $14.99, and this month it is only $9.99. So we've got a great deal going on our family estate packages right now. And those will include transfer on death. We include those, whereas many estate planning attorneys do not, because it's not what their clients need. So, okay. Any questions? And we'll just kind of hang out for about 3 or 4 more minutes while anyone asks a question. And if there's no questions, then I did a good job. So it's up to you.